All right, so I'd like to welcome everybody to this CLE that Doug and I are giving. As from the title, you can tell, it's about new employee stock ownership. And let me see, do I have control over this yet?
Working on it.
Okay, well, I'll just talk while this is getting set up. We're at Bend Law Group. I've been here for about 3 years. Doug started it over a decade ago, so it makes sense why he has been so well known in the Attorney Action Club or committee, and also the SFLN. So I think I have some control now. Let me see here. Do I? I don't. I'm controlling your screen now. Cool. Or no, I'm not. Oh, there we go.
There you go.
All right. So, so a little bit about me. I was born in Milwaukee and moved here to California in 1988 when I was about 7 years old, and have been a big fan of this state ever since. I haven't moved back to Wisconsin for any reason because it's cold and it's nice here. So, I graduated from UC Davis Law School in 2012. So I've been an attorney for about 9 years now. But I originally went to undergrad at UCSB, and I guess I didn't learn how to spell gaucho. But anyway, I was a theater major, and at the time I directed a lot of plays and did some acting. I dabbled in a little bit of film after I graduated, and then went over to law school at UC Davis. And I've been with Bend Law now. It's actually probably closer to 3 years now, but I've been practicing corporate transactions since 2016. Prior to that, I was an intellectual property litigator over at Bunso DeMori. Did a lot of patent litigation and some trademark and copyright disputes. And here we are. So with that said, I'll pass it to Doug to take the reins here.
Well, thank you for having us for a couple of reasons. The first reason is that it's a beautiful day outside, and you guys are spending it with us instead of being outside enjoying the sunshine talking about equity, right? So thank you for that. As Brandon mentioned, we started the law firm back in 2010, and really early on, both SFLN and Attorney Action Club were really important when I first started my firm. Really having that community there of other attorneys that were going through what I was going through, and to have referral partners who I got to know over time, who I trusted to send clients to, really made a really big difference. And so I just want to thank the group for that for over the years, and happy to have the opportunity today to present, to add a little value back to the group. Let's see here. I'm having trouble controlling the screen. There it goes. So for some of you, I might be the first and only person you've ever met from Nebraska. And that's partly because there's only about 10 people in the whole state, and everyone else stays. And so might be the only Nebraskan you've ever met, which puts a lot of pressure on me because it's the one person you can associate with the state. But I did grow up in Nebraska. My folks are still back in Nebraska. Got a master's degree at Nebraska in political science after going to college in Iowa. And then I worked for a congressman at Capitol Hill for a couple of years doing small business issues, tax and budget issues. Graduated law school from Georgetown, and then was practicing in a big firm in New York City before starting my own shop back in 2010. So that's just a little bit of context. Grew up in the Midwest, but been out here in the West Coast now for a decade plus, and definitely do not miss the Midwestern winters like Brandon mentioned. So a little bit about our firm, and then we'll jump into the topic for today, is that we really just focus on nothing but helping out business owners and entrepreneurs. We help set up over 50 new companies a year. So we often get involved early on. We often work with some later stage companies, typically if they're complaining about their current attorney because the bills are too high or not being responsive. they might switch over to us. But work a lot of early stage through exit. Do a lot of equity agreements, both for new companies and companies that are growing and expanding. A lot of buying and selling companies, trademark applications, raising capital. So a lot of the transactional stuff that business owners are going through is really our bread and butter and what we like to focus on. So, today's topic, I think when we have a client that comes to us and asks us, I want to give equity to an employee, whether it's a law firm employee, a bar, a restaurant, or a startup, really the first, topic I'd like to chat with them about is, are you sure? do you really want to give them equity? And maybe think about some other options besides equity. And really the reason for that is because once that person gets the shares, unless they're subject to vesting or some sort of repurchase right in the shareholders agreement, they own those shares indefinitely, and they'll be getting distribution payments from the corporation indefinitely. And if the company is acquired 10 years after they leave, they get a percentage of that company. And so it's really thinking about, do you really want to issue shares to the person? Do you maybe instead want to have their comp tied to how the business is doing or how they're doing at the business? So, one of the advantages of being a shareholder is that you get a percentage of the net profits. Well, there's nothing to say that you can't put in an offer letter that as an employee of the business, that they could get a percentage of the net profits for their bonus each year, right? So maybe you want to have them get some of the upside of how the business is doing without them actually owning shares. And then if they actually do own shares, is thinking about things of, well, okay, like maybe put an agreement into place where when they leave the company, maybe you want the company to have some sort of repurchase right, saying, okay, it was great that you were a shareholder while you were with us. You're no longer with us. Perhaps the company has an option to buy back the equity for the then fair market value for whatever they bought in at. And so that person isn't continuing to see net profits and a percentage of the acquisition price that the company's ever acquired. So long story short, that's really the first question is, are you sure you want to issue shares? Maybe there's some other options you should think about. If you do want to issue shares, perhaps you want to put in some of these protections to protect the business long term. And of course, often people do want to issue shares even after that conversation, because someone that owns a piece of a company, they just view the company differently. I think psychologically, consciously or subconsciously, when you own a piece of the company, whether it's a bar or a restaurant or a law firm or a startup, you feel more vested. You got skin in the game with that business. And when another employee is, giving rounds of drinks at the bar to all their friends, maybe you're more likely to say something when that's, coming out of your pocket, right? So that's really some of the upside of really equity is that the feeling that people have a piece of the business, they view the business differently, they really care more about the business than if they don't own shares, even if they're getting a percentage of that particular year's net profits. So who owns a corporation? Well, I think it's keeping in mind that there's these distinctions between the number of authorized shares versus the number of issued shares versus the number of outstanding shares. And when you first form a corporation, in the articles of incorporation, you authorize a certain number of shares. And so the corporation has X number of shares. Often it depends on where you're forming the corporation, the purpose of the corporation. Say it's 10 shares. Well, the number of shares the corporation has to issue out to people over the lifetime of the corporation. But from day one, no one owns shares in the corporation. They're authorized in the articles of incorporation, but they've not been issued to anyone. So no one actually owns shares in the corporation. And so to actually have an owner of the corporation, you have to issue those shares out. Typically early on, it's to the founders using stock purchase agreement. And at that point, that's when someone first owns part of the company, is when they've actually been issued shares to the company. So just because a corporation's been formed doesn't mean that right away that anyone actually is a shareholder and owner of the company. So for example, in this hypothetical, Charlotte forms a new corporation for an app. The articles of corporation authorize 10 million shares. From day one, who owns this corporation? And right away, there's no shareholders. There's technically nobody owns the company right out of the gate. And so if Charlotte were to, at that point in time, issue herself 7 million of the 10 million authorized shares, she would then be a shareholder of the company. She'd be the sole shareholder of the company. So how many, what percentage interest in the company would she own? Well, it'd be 100%, so you'd be, even though she owns only 7 million of the total 10 million authorized shares, there's no other shareholders. And so what really matters when calculating the distribution payments she's getting as a shareholder of the company, or the amount that she would get if she were to sell the company, she would get 100%, because even though she doesn't own all the authorized shares, she owns 100% of the issued shares. And so early on, you often have, the founders getting stock purchase agreements from the company. They fall into a certain securities exemption for getting stock in the company as founders. But when you start to add on employees, that safe harbor for that securities exemption no longer applies. And so the best way to issue equity to employees is through an equity incentive plan. Some people call it a stock plan. But essentially, that plan reserves a certain number of the total authorized shares for employees and advisors and consultants. And it depends how the plan is drafted, but most plans have a variety of ways that shares can be issued from the plan. And so early on, before the company has raised any capital, it's often through stock awards, stock grants, where you're awarding the stock to employees and to consultants. Once the company has raised capital, particularly a Series A round, or if they have a significant amount of revenue, of income, often the fair market value of the company in the eyes of the IRS has gone up. And so if you just grant stock to people or award stock to people, they either have to pay the same amount per share for that fair market value of the company, or recognize as taxable income the difference between the fair market value and what they pay. So you often see this transition, particularly at the Series A round and above, where the company switches over from stock awards and stock grants to doing stock options. And the key distinction there is the stock options, you're not actually a shareholder when you get a stock option. It's the option to buy stock down the road. And so people aren't buying the stock on the day that the option is issued to them. They can kind of see how things go with the company and decide to exercise that option down the road, instead of having to go out of pocket the day that they're issued the option. So here's just a little bit more about equity incentive plans and some of these distinctions between, actual ownership in the company and fully diluted ownership in the company. And I think really the point that I'd like to make here is that, we see this a lot where we have clients come to us and they say, here's the email that I got from, the founder of the company. I'm joining this company as an employee. The email says I'm going to make X amount a year, and they're giving me 0.5% of the company. And really, it's, you kind of see from these different examples here, it's like, well, 0.5% of what? Are they talking about 0.5% of the total authorized shares? So in the case of 10 million authorized shares, or are they looking at give you, 50,000 shares? Are they talking about 0.5% of the fully diluted shares? And so a lot of our job when we're helping clients who are going to go work for companies is kind of fleshing out, what they're making sure that they understand exactly what percentage of the company that they'll be getting, that they're likely to be diluted down when shares are subsequently issued to other people. So they have a better sense of exactly what the upside is of the shares that they're getting from the company. And so, again, we mentioned before, it's really, what really matters most is not the number of shares you get from a company. Because if you're getting 1,000 shares of a company that has 10,000 authorized shares, you own 10% of the company. Where if you're getting 100,000 shares of a company that has 10 million authorized shares, you own a much smaller percentage, right? And it's really all about, what matters most is about the percentage of the company that you own. So it's really understanding how many shares is a company looking to issue to you, how many shares have been issued to other people, to get a sense of the actual ownership that you have in that particular company. So we see this quite a bit. It's where are the shares coming from, right? And I think a lot of people, some of the common mistakes we make is people form a corporation, they authorize 10 million shares, and perhaps they issue all 10 million shares to themselves out of the gate, and with the plan of, well, I'm the owner of the company, I want to own all the stock in the company, and when people come out along down the road, I'll just transfer some of my stock to those people that later join the company. And that's really not the best way to go about it for a few different reasons. Instead, typically, we recommend founders of companies leave some shares in reserve for future people joining the company. And a lot of it is due to tax consequences for people that are involved with the company. And so if the founder instead transfers shares from themselves as an individual to employees that are joining the company, there's a risk there that might trigger capital gains tax for the founder. And so if the founder bought their shares in 2010, for $1 a share or 0.0001 cents a share, and they're selling their shares to somebody in 2021, presumably the value of the company may have gone up over time. And so if they're selling their shares for more money, that could trigger personal capital gains tax for them. So instead, it's typically recommended that the shares are issued to the employees directly from the company to avoid that type of potential tax liability for the founders. So here's another hypothetical with Charlotte. She's looking to hire some more people to join her company. How should she issue the shares to these new people joining the company? Well, she shouldn't, ideally not transfer the shares from herself as an individual unless she's looking to get some liquidity out of the company. That really is not the best way to go about it. Ideally, it's issued directly from the corporation. And to avoid those types of particular tax consequences for her as an individual. And also, it's sometimes easier to fall in particular SEC security regulations when it's being issued from the company than herself as an individual. So here's just another example of what we talked about before, talking about, she's issuing 80,000 shares to somebody. So if you have a client that comes to you and they send you a stock award for 80,000 shares in the company, I think the dialogue we'd recommend having with your clients would be, well, we need some more information here, right? So 80,000 shares, what does that mean? Often we'll ask the company to send us over an endorsed copy of the articles of incorporation so we can see how many total authorized shares the company has. We may ask the company for the number of shares that have already been issued in the company to help our client get a better understanding of exactly what percentage ownership that they'll have in the company, and to make sure that aligns up with the agreement that they made with that company when they decided to join that particular team. So it's the Bay Area. There's a lot of crazy people in the Bay Area. A lot of people look good on paper. A lot of people interview very well. A lot of people don't back up the big game that they talk or the big game that they look on paper. And so Brandon's going to talk a little bit about what happens when you hire somebody and they show up and they're not what you expect and they're not meeting the type of expectations you had for when they join the company. What type of options does the company have to protect themselves? So Brandon, take it away.
All right. Thanks, Doug. Yeah. So, Doug did a great job of explaining the concept of the equity incentive plan and the how to sort of divvy up ownership percentages. But it's not unheard of that some of your early service providers, or even sometimes the founding team, they might just not be what you expected to. They might, since it's their first startup, or since it's maybe a marginally successful startup, some of them kind of lose their minds and they check out mentally, or they might have other kind of personal issues that make them no longer able to perform their duties for the company. So one thing you're probably kind of thinking about is, how does the company protect itself from that scenario when I just gave them, maybe 1% or 10% or, maybe even more than that in shares if they're a founder? And the answer to that question is the vesting schedule, or how I kept my new hires. And the vesting schedule is it's a time period where you're incentivizing their continued employment and continued performance. So usually in the documents that you use to issue them shares, whether it's the equity incentive plan itself or the stock purchase agreement, stock grant, option grant, whatever it is that you're using, there will be terms in there that say, if you quit or the company terminates you for any reason, the vesting schedule ends. In certain cases, there might be acceleration clauses that relate to being terminated with or without cause. But I'm not going to really get into that right now, because for the most part, when we're talking about just a simple equity incentive plan, where we're talking about those early hires and not the founders, we're not necessarily going to consider those accelerators. So, but the concept of the vesting schedule is kind of misunderstood pretty often. When shares in particular, and what I mean by that is shares and not options, when they're issued out of an equity incentive plan and are subject to vesting, they're owned, right? So if you get an 80,000 share grant, then you own 80,000 shares, even if they are subject to vesting. The only way that the company can protect itself is by saying, hey, if you don't meet these terms, then we get to claw those shares back at whatever, however we gave them to you. So the misperception is that the grants aren't owned until they vest. No, they're owned, but the company can take them back. And if we're talking about a share grant, it probably means that they were issued very early, meaning they're at a very low price. So the company's consequences of repurchasing those shares are pretty low. So it'll be a good incentive to say, yeah, I can buy those shares back for $8 or 80 cents or whatever it is that I gave them to you for, and that's going to kind of hurt you. So you have to meet those. Usually it's a time-based qualification, right? So there'll be a cliff date of 1 year is common, and then 1/48 of the entire grant will vest every month after you reach that cliff date. That's the most common version, but there are other, plenty of other triggers, and you can be pretty creative with that. So yeah, then
I'll just add a couple of things, Brandon. So, I want to mention, it's not always just because the employee isn't doing a good job. There's a number, they could fall in love with someone in France. They could get their dream job at Google. They could have a sick relative they want to move back home for. So there's any number of things that could come up where they're not with you as long as what you would like them to be with you. And really the goal of the vesting schedule is to say, while everything is sunshine and rainbows when you're starting the company, let's put a game plan into place of what will be fair for when you leave the company. If you were to leave the company after 1 year, 18 months, 36 months, let's put that game plan into place on the front end. And so if that were to happen, we have an amicable way to transition you out that's fair both to you and to the company.
Yes, and it's also worth pointing out that the company doesn't necessarily have to follow through with the vesting schedule. I mean, it's an option by the company, right? So if the person, leaves and the company voluntarily says we'll continue or vesting, or we'll vest a certain number of shares just as a courtesy to you because we really did appreciate your your contributions, the company can't do that. So the contract is malleable insofar as the company wants to allow it to be, but the automatic expectation is that when we're talking about a time-based schedule, the company is going to be taking back those shares that weren't vested. So, and in the case of options, they're not really clawed back because they're really sort of just a, it's not really, it's sort of a vague concept because you don't own shares in the company. It's sort of considered a collective option, but those parts of the option that haven't vested, they're just canceled outright. So anyways, so yeah, as I mentioned before, the typical schedule is 4 years, 1 year cliff date. The cliff date means you get nothing if you don't meet that date. So the typical cliff date is 1 year out. So if somebody's hired May 1st, 2021, then they're not going to receive any shares, or at least get to keep any shares until May 1st, 2022. pretty straightforward. So yeah, back to the hypothetical. Profex Inc. Charlotte had one of her new hires take her shares on December 1st, 2020, and was terminated today, September 2nd, 2021. It's a shame, because I'm in a pretty good mood today, but apparently Charlotte was not. So how many shares does she get to keep? Well, assuming that the traditional vesting schedule is chosen, none. And the reason why is because she only made it through about 9 or 10 months. I can't count. Either way, she didn't make it a year. And in order to have vested and any of those shares, she needed to make it through that first cliff date. And again, the cliff date, you don't have to have a cliff date. It's just consistent with startup practices to have a cliff date. But yeah, didn't make it a year, only made it till September. Had she made it to December 1st, 2021, she would have gotten to keep a certain percentage of those shares. So in an alternative world, the other new hire took her shares on August 15th, 2020, and was terminated today on September 2nd, 2021. How many shares does she get to keep? Well, lucky for her, she received the grant of 80,000 shares, and she made it to her 1-year cliff date. So she keeps 25% of those shares, which is 20,000. And the company, and to be clear, not Charlotte, it's the company that's repurchasing her shares. And to repurchase the remaining unvested 60,000 shares at their original issue price, which I've set at the most common par value, which is $0.00001 per share, or for 60 cents. And I think that kind of highlights why the vesting schedule is so important. It's because, the company's incentive to take them back if the company or if the employee isn't performing is pretty good. And it's also, you can see the benefit that this employee just lost out on. And so if their performance isn't up to par, then they've basically given up what could be a substantial increase in value of those shares later. So that brings us to.
Hey, Brandon, let me just one more point on that. So I think really, for our job is really two things. One is to identify, risk for our clients, and then two, if we can, try to improve the agreements. And that 1-year cliff is really, when you look at equity agreements, that's really one of the biggest risks that our clients have. And we had a deal this last month. It was a client of ours, was at Google, had a really great job at Google. The startup recruited him and was identifying for that client that you could leave your 6-figure job at Google, go work for the startup, be there for 9 months, 10 months, 11 months, and they could fire you, and you can get 0 equity. So you gave up this great job with all these benefits and a 6-figure income and walk away with no equity. What we tried to negotiate for them was initially have it be month-to-month vesting right out of the gate. And so after that 1-year cliff, each month you vest an equal amount until you're fully vested. So we try to have the monthly vesting start right away. The company didn't go for that. We try to negotiate a shorter cliff, and the idea being, what is the purpose of the cliff? Well, the purpose of the cliff is to make sure that you are a good fit for the company. And if you're not a good fit for the company, that the company doesn't have to go out of pocket on any of its equity. So maybe a 3-month cliff, a 6-month cliff. And for that particular client, at the end of the day, it was just too much risk for them to go away from this great job that they had, unless the company was maybe a little more flexible on the vesting schedule and the duration of the cliff. And then the last thing I want to mention on that section was that probably 99% of equity agreements on vesting schedules in the Bay Area are on this 4-year vesting schedule with a 1-year cliff. Sometimes we'll see the cliff a little longer, a little bit shorter. Sometimes we'll see the vesting period be a little longer, a little bit shorter, but the vast majority of these documents are on that vesting schedule. There's nothing by statute, though, or anything like that, where you have to have that vesting schedule. And so we have had some clients and some employees have gone to work for companies that the vesting schedule isn't all time-based, or perhaps it's not time-based at all, and they use other triggers, right? So once the company raises a Series A round, you get X shares. Once the company has at least $1 million of gross revenue, you get Y shares, right? And so if you want, you can get creative on the vesting schedule and have it not just be, time-based if there's other metrics you want to base it on.
I had a question about the cliff date. So once you hit the cliff date, you're not starting at 0. You just have to hit that or you don't get anything.
That's correct. So if you hit the cliff date, so you're not starting at 0, to begin with, right? As we mentioned before, if the grant is for 80,000 shares, and I'm talking exclusively about shares right now. I can opine on options in just a moment, but if we're talking about shares, you own the 80,000 shares, right? So the cliff date says that if you leave before that date, then you get nothing, or the company can at least take back the amount that it wants to, which is any or all, right? So if you hit the cliff date, that means 25% or 20,000 of those shares, the company can't claw back, absent some other terms in there, but usually you won't see that unless the company is really kind of being a little, like, I don't know, unnecessarily overbearing on keeping ownership close to the vest. But for most startups, you don't see that. So once you hit the cliff date, you're not starting at 0. You have everything, but now 25% of that can't get taken back. You get to keep it no matter what.
Okay.
And I'll say, if you're on the employer side, so if you're the law firm or the startup or the bar that's issuing equity subject to a vesting schedule, it's not the worst idea to set a Google Calendar alert for 9 months out, 10 months out, to kind of do a check-in to prompt you, to remind you, okay, this employee on December 1st, they vest 25% of their equity. How are they doing? Is this someone that I want to vest that much equity, that first tranche, if you will, on equity in 2 or 3 months? Or do I want to consider renegotiating that equity grant to be a lower amount, or let them go altogether? And so if you're on the side that's issuing equity, keeping in mind when that first tranche hits, when that first cliff hits, and perhaps setting a reminder for yourself a few months in advance to do a check-in to make sure things are on track.
Right. Yeah. So moving towards the 83B election, this is sort of a buzzword in startup worlds. A lot of times I get clients who reach out to me and say, what do I do about my 83B election, with little to no knowledge of what that even is. And so basically it's based in some, in some general basic consequences of what income is and when income is realized. And I should preface this by saying, we're not accountants, and none of this should be construed as tax advice. This is just laying the groundwork for what the election is and what it could mean for you. If you have questions about whether or not you should file an 83B election or what that means for you, always check with your CPA, or you can check with a tax attorney. We're not tax specialists. We just know that this is something that companies will need to kind of not hold their employees' hands, but make available for their employees. And so the question is, well, why? What does it even have to do with, right? So the answer is that in a general sort of philosophical sense, you realize income whenever there's an increase in wealth to you, right? And so a lot of times we see that when people receive money, right? A company pays you for your services, you put it in your account, and now you've realized some income. The same thing is true when you're receiving shares. And when the company says, okay, here's shares, or they write a document saying you're going to get shares, or that you do get shares, or here's how you get shares, a question that often goes through our client's mind is like, well, what do I do with that now? And, what are my tax consequences? I don't know what your tax consequences are because I don't know what your income looks like. So again, just, CYA right here. But the answer is sort of based on some information that the IRS has put out there about when somebody takes control of property, and that property being shares, and what that and the timing of that with respect to your vesting. So the IRS generally requires that you realize income when you take control over some property that you're receiving as payment for services. And so if you if you take shares that are subject to vesting, technically you don't control those shares really, right? I mean, you do, but they're subject to substantial forfeiture. So this is kind of a weird juxtaposition of like, I own them, but I don't because I could lose them, right? So you can kind of control them, but you don't. You could vote them if you so chose to, but the company could take them back. And so it's a little bit of a wonky area that the IRS has given people the option to make certain elections for that can like it could lower their tax consequences later. And so when over time, people take control over their shares when they vest, right? So there's no way for you to lose your shares unless you choose to sell them or there's some other kind of condition that your shares are subject to after they've vested. And we just talked about that, right? You know, if you've reached your cliff date, you have 25% of your shares in your possession, the company can't buy that back from you. And so in theory, the IRS would say, now that that's vested, you've taken control over that property. And for that reason, we'll realize income on today's date and you'll pay us whatever the tax consequences are for that. That can be pretty consequential, right? Because over the course of a 4-year vesting schedule, shares can increase in value. You know, some companies can go from nothing to an IPO in, just a few years, right? So it's not common, but if they're starting to bring in, large funding rounds of millions of dollars and coming in with valuations of hundreds of millions of dollars, and you own, 2% of that company, and now you're seeing tax bills for $20 million worth of shares. If you're having to realize income every single time the vesting schedule is hitting, now you're having to say, oh my God, like how much am I going to have to pay for that? That's going to be absurd. And so the IRS allows you to make the 83B election to realize income of the entire grant, not just the vested ones, but the entire grant immediately at their grant. And by immediate, I mean very, very, very immediate. So to highlight that point, and I put it in red, you have to file the 83B election within 30 days of that grant. And there is no exceptions to this rule. And I really, really mean it. There are no exceptions. The IRS doesn't care if you didn't know the rule existed. They don't care if the post office lost it. But pro tip, if they did lose it and you sent it via certified mail, save the certified mail receipt. We recommend sending it via certified mail because if you do that and you save the receipt, you have proof that you sent it in, and that will, that'll save you later on if you're ever audited. And because you can prove up that you sent it and that it was received, and it's not your fault if they lose it. So you just have to make sure that it gets submitted. So that's a really important point. Don't miss that deadline. Make sure when you sign that document, you go and you file it and you mail it to the IRS. There's only 4 addresses in the US. Send it to Utah. That's where you're probably going to send it if you're in California. So anyway, so Professor X, Prof X Inc.'s employee, Jean, received her 80,000 shares on March 1st, 2021 at a price per share of $0.00001. Since it was snowing during the spring months this year, she sent her 83B election to the IRS on May 1st, 2020. What are her tax consequences? The answer is, again, I don't know, but she was late, which means that she is lost out on the opportunity to file her 83B election, and she can't take advantage of that early opportunity to realize the income immediately upon receipt of the shares. Now she has to wait over the course of the vesting schedule to realize income, at the cliff date, and then every single month thereafter. It's going to be a headache. Nobody wants this. So she must calculate a fair market value for the shares on March 1st, and then report that income report that to the IRS as income, and then keep doing it over and over again. And usually the in a quick sense, the company will do this for the employees by providing them with what's called a 409A valuation, which is the company giving them the information they need to assess the value. So if it's a high valuation, then that's going to be a lot of, it's going to be a pretty big bill. So don't forget it. Profex Inc.'s other employee, Monroe, received her 80,000 shares on March 1st of 2020 at a price per share, same price, $0.0001. Monroe sends her 83B election to the IRS on March 7th, 2020. What are her tax consequences? Well, great, you were on time. So now she gets to realize the 80 cents in income that is the value of her shares, and she's not going to see any tax consequences until she maybe sells her shares later. So there could be long-term capital gains rates to apply to those sales if it's further down the road, at least a year. You know, sometimes employees can also see some QSBS tax treatment, but I'm not even going to get into that. It's just, there's a lot of good things that can come of somebody who is responsible and submits their 83B election on time. And as always, check with your CPA, see if it makes sense for you. But, you know, I think the writing's on the wall. It's a pretty good option for people who are receiving shares very early in the company. So moving on to the next concept of grants through an equity incentive plan is the option. A lot of times you'll hear companies refer to the equity incentive plan itself as an option pool or a stock pool or employee option pool. Options are not actually share ownership. It really is just an option to eventually take ownership of shares upon you know, vesting and, you know, exercise of the option. When we say exercise, you know, it's kind of considered similar to, you hear exercise price or strike price, they're the same thing. So when we strike an option, it means we've exercised an option. It just told the company, hey, I'd actually like to take ownership of these shares because, you know, I see the company is doing well. And so I'm going to buy these shares at the strike price or the exercise price, which if you're doing that, it probably means that the company has seen a lot of improvement in its value. And now you're going to take ownership of something that has a lot more value than what you're paying for it. So anyways, how does that relate to 83B elections? And I get a lot of clients who, when they receive options, you know, those options are similarly subject to vesting schedules, meaning there might be a cliff date. And then after that, you know, there's a monthly vesting schedule associated with you know, those options. And they'll ask me, do I need to file an 83B election? And the answer is basically not usually. And I already went through what is an option. Obviously, it's an option to purchase shares at a particular price later, which is the strike price. And so yeah, back to the schedule. You are allowed to strike them when they vest. The exception to that rule is an early exercisable option. And that's sort of a mixture between the benefit of share ownership and options. And what I mean by that is typically a vesting schedule that's applied to options means you don't have any right to strike until the option vests. So some companies will say, well, you can actually strike the option, but we still want the ability to take the shares that you buy after you've stricken the option, after you've exercised. We're willing to let you have those shares, but we still want to be able to claw those back at their original issue price if you don't meet the vesting schedule. So in other words, you have 80,000 shares, they're issued to you at a strike price of $1 a share. you're 9 months in, you decide, hey, I want to exercise my options. Since these are early exercisable, I can do that. So I pay the company $80,000, but then I quit a month later. Well, the company can say, hey, you only made it to 10 months, and these were early exercisable options. You took ownership of those shares, but those shares kept their vesting schedule. So we're able to buy those back at their original issue price, which is the strike price. So that is important because it relates to the exception to whether or not an 83B election is even relevant to options. So when we're talking about the 83B election, as I said, since options don't give you ownership over shares, technically the 83B election doesn't have any relevance, and you wouldn't actually own them until you actually exercised. And so the 83B election isn't relevant. But if you took ownership of those shares before the option vested, meaning they're early exercisable, then the 83B election is relevant because they are subject to substantial forfeiture. So based on the hypo that I just gave you, right? So if you're 9 months in, you exercise, a month later you leave, the company can still buy those back. So that means that you have ownership, right? And the IRS has said that you realize that income, and now you can get those clawed back. The IRS will allow you to file an 83B election to protect yourself from the tax consequences of that same vesting schedule continuing after you exercised early. And that is really complicated, and I'd welcome you to ask me any questions about that if you did have any, but hopefully that's as clear as mud based on what I had just explained. So as I just offered up, the simple way to explain it is if the options are subject to vesting and they're just regular options, they don't require an 83B election. There's no harm in filing it, but if you're not sure, feel free to file it. It's not going to hurt anything. But if they're early exercisable, which is a very important distinction, then check your agreements. If it says early exercise in there, that means they are, and that means you will want to file the 83B election within the 30 days of grant, just in case you decide to exercise early. So that's the distinction. If they're early exercisable, consider the 83B election. If they're not, file it if you want, but it's not really going to be a meaningful tax consequence or realization of any income. So
I'll say, I think the biggest gotcha with stock options is that most stock option plans, they include a provision that once you're no longer providing services to the company, that your options expire after a certain number of days. It's often 60 days or 90 days. And so someone could work for a company for 3 or 4 years and think they have all these options, and they stop working for the company and they don't exercise those options once they leave. Well, those options may expire, they may terminate, they may go away. And so if you're an advisor to a company, or you have someone in your family who's getting stock options, they're thinking about leaving the company, I think it's looking at the stock option plans, seeing if they have that option termination provision, and then secondarily having some money set aside to be able to exercise those options if that's what you like to do.
Yeah, it's important. Most commonly, you'll see those post-termination exercise windows to be about 30 to 90 days. So it's a pretty short window. Be careful about that because it's true. Some people just don't realize that the window even exists. So moving forward a little quickly, since we are running a little shorter on time here. So Bishop joins the Profex team and receives 80,000 options, subject to an ordinary 4-year vesting schedule with a 1-year cliff date through the equity incentive plan. What is Bishop's ownership? Because he's received options, he doesn't actually own any shares, and thus no ownership in the company until he exercises his options. So can he file an 83B election? The answer is, sure, but they're not going to be subject to early exercise, so the 83B election is probably not useful. But again, Bishop, reach out to your CPA to decide whether or not you should. Have them read your agreement, see what it says, And if there's some indication that it's early exercisable, by all means, file it. So in an alternate universe, Bishop joins the Profex team on May 1st, 2020, receives 80,000 early exercisable options subject to the ordinary vesting schedule. Can he file an 83B election? If recommended by a CPA, of course, he can take ownership of unvested shares, which is the whole benefit of an early exercise, is that you can take quick ownership and, but they'll still be subject to forfeiture. So an 83B election could really have some substantial benefits to him. So by all means, file it. So what is his deadline if he received his options on May 1st, 2020? Also, this is a little, I would say this is actually kind of undecided, but really it should be May 1st, because that's the safest deadline. But I think it's kind of an unanswered question of whether or not you are required, whether the clock starts ticking at the time that you exercise or the time that the company issued you the grant of the options, right? So in other words, when you have options, you don't own anything. So how could you really have the clock ticking at that point? So it's possible that you might say, well, I haven't taken ownership until I exercise, and I exercised 5 months after I was granted these shares, or these options, and now I own the shares. So shouldn't the clock start ticking then? And the answer is, I don't know. I don't know that it's an answered question, but to be safe, file it within 30 days of the grant, just to be careful. So, this next part of the hypothetical, he mails his 83B election on time, and then he exercises early on July 15th. On September 23rd, the company finds out he's been sharing code plans with a competitor and they fire him. How many shares does he get to keep? The answer is none, because he still did not meet his 1-year cliff date. He took ownership of the shares, but the vesting schedule was still in place because they were early exercisable options. And so since he was only there for, a handful of months, he doesn't get to keep anything. RSUs, so we're about at the end here. I just wanted to bring up a couple of alternative forms of incentives that companies might offer to their employees as an alternative to the equity incentive plans. And these are really, you can consider them kind of an expansion of the concepts that are enclosed within equity incentive plans. But a lot of times you'll hear of companies offering up RSUs and or shadow stock as part of their plans. RSUs are restricted stock units, which it's basically a pool of cash equivalent to the price of a certain number of shares of stock at a given point in time, or averaged out over a particular period of time. It's really confusing, but what you can basically say is, if I have 10 RSUs and the current share price is $1 a share, that means I get $10 to try and buy some shares. But in order to protect myself from some tax consequences, there might be an ability to not take all those shares and instead give some of that cash back to the company to cover your tax consequences. So this is more relevant for when the company is later stage. And if they're kind of issuing you like something that's, stock that's worth like $20,000, obviously that's a huge tax hit. And so it's harder for you to sell shares to try and meet those obligations. So this is like cash, right? They're like, here's $20,000 worth of shares, kind of, but we're really just giving you $20,000 for you to buy shares at a certain price. But since, anyway, it's complicated, but it's a different kind of equity grant that you can take advantage of later. So they're kind of similar to options, right? You don't actually own shares when you own RSUs. You own the right to buy shares and realize income immediately during, at vesting, different from options. You have the right to buy the shares, but you don't have to. So you can kick those consequences down until you exercise. RSUs are basically like exercising immediately when it vests. And then the last example of an alternative form of an incentive plan is shadow stock or phantom stock or phantom units. Basically, it's not share ownership. It's not options. You don't have a right to buy shares. You don't have a right to receive shares. It's a future right to participate in the sale of the company. It's reflected by percentages or share prices. Either way, nothing happens. You don't get anything until an event happens in the future. And usually we're talking about the exit of the company, right? The company, is bought out for $10 million. You own essentially a 1% interest in phantom units or shadow stock. So you actually get to participate in the proceeds from the sale of the company in the amount of 1% of whatever is sent to the stockholders. So it's kind of like you have stock, but really all you have is the financial benefit of the sale of the company. Or if it merges, you might receive some shares of property as part of that merger to satisfy the obligation of the shadow stock. But long story short, you don't own anything until the event happens. Usually the event is an exit, meaning a sale of the company or a merger. And at that point in time, you'll get whatever increase in value exists of those shadow stock, or if it's just based on a flat percentage, you'll get like a percentage of the sale of that exit. So I tried to move through that kind of quickly. I'm going to not get too much deeper into the shadow stock plan there because it is a little bit different. But if you have any questions, by all means, you can pose them now, or you can email me or Doug at our email addresses below. And that pretty much wraps it up for me. I don't know if Doug has anything to add here to close, and feel free.
Yeah, I'll just say, two things. We covered a lot of ground. I would say that if anyone is getting stock, there's probably 4 biggest pitfalls to be looking for. So the biggest pitfall is, that cliff. And so if you're an advisor to a startup or to a company, it's just being aware of that cliff, that you might be providing services, and if they cut you off before you hit the cliff, you could walk away from nothing. So that's number one. Number 2, it's in the agreement, paying attention to what they state in the agreement as the vesting commencement date. And so if they send you an equity agreement today on September 2nd, but you've been providing services for 3 months, well, your vesting commencement date should be when you first started providing services to that company. So you shouldn't lose credit for the time that you've been spending on that company. Number 3 is that if it is subject to vesting, filing the 83B election, the good news, within 30 days, we get several calls a year where people miss that deadline. The good news is that some tax forms are very long and very complicated. The 83B tax election is a 1-page form, and so filling it out doesn't take very long. That's not the issue. It's the issue with meeting that 30-day deadline. And then lastly, it's if you're getting stock options, you're no longer providing services to the company. Take a look at that stock option plan to understand if those options terminate, and if so, making sure that you timely exercise those options if you think the company is going somewhere.
And just a reminder, these slides will be provided. Brandon and Doug will be CC'd on that email, so you'll have access to their email addresses if you have any questions.
Thanks, Doug. Thanks, Brandon. That was excellent. Very eye-opening and understandable.
Well, we're glad it was eye-opening and hopefully not a complete snooze fest. It is equity. We try to snazz it up a little bit with examples here and there, but we really do appreciate everything both groups have done for the firm, and always happy to help out other members of the firm in any way, whether it's questions on equity agreements or just running a practice, however we can be of help. And if you guys have stuff that comes up for your clients, when it's referred in by someone we know, we don't charge any sort of consultation fees. So we're happy to talk to people about these types of issues as they come up.
A lot of us are maybe some of us may be managing just small professional corporations. Does your firm help people like that, or do you have any advice for folks that are managing small professional corporations?
We do, and it's really, there's the 2 biggest challenges there are what is going to be the buy-in price, right? And so if you've had a law firm for 10 years and you want to give equity to lawyers, are they buying in at fair market value, which could be somewhat high, right? So you're going to have them write a check for hundreds of thousands of dollars to get a piece of the firm. So what is going to be their buy-in price and determining what's fair on that? The second biggest issue is what's the buyout price, right? So presumably you want triggers when they retire, when they die, become permanently disabled, if they're no longer working for the firm. What is going to be the repurchase price? Is it good? If they're buying in a fair market value, perhaps it's fair for the repurchase price to be fair market value. And then from there, just not to sound too much like a lawyer, but what is fair market value in quotes, right? Is it going to bring in an appraiser in to appraise the then current market value of the law firm? Is it going to be an equation where you agree ahead of time that it's going to be X amount of the prior year's gross receipts, right? But I say those are the two biggest issues: is deciding what the buy-in price would be. On the one hand, you don't want it too high because that's not going to be the incentive you maybe want for people at the firm. But you also want to get value back for all the work that you put into it over the years. And then what's the buyout price if they're no longer working for the firm?
Noel asked a question in the chat. Are there any instances of cryptocurrency being used instead of stock?
Well, I would say that I guess you could, but the cryptocurrency itself, it really would just be treated as income, right? It wouldn't really be considered like equity in the company. Though part of me, my brain is saying maybe there could be like NFTs associated with the company, and it's possible, but this isn't something that's, I think, been contemplated in the IRS or anybody else's mind as to its association with companies' ownership, right? Unless the company itself is kind of represented by cryptocurrency, which would be an interesting thought and concept. I don't know.
I'd say that there was that article recently about the NFL football player that took, he did his contract in Bitcoin, and then the value of Bitcoin went up, so the value of his contract went up substantially. We're not seeing too much of that yet. I think the reason why is that, I'm not a CPA, but I'll pretend to be one for about a minute, is that I think the concern there is that the IRS, if you're giving someone $10,000 worth of Bitcoin, they have to pay taxes on that $10,000 value of Bitcoin. And so why not just give them the $10,000 in cash and let them decide if they want to buy Bitcoin or Ethereum or stock in Apple?
Yeah. Sheldon sent me a question, kind of a scenario. If an employee gets dismissed prior to the year one cliff date, and the company is legally deemed to have unlawfully dismissed that employee and has to reinstate the employee, but the employee elects not to return to the company, is the employee entitled to those cliff date shares?
That's an excellent question. I would argue no, and the reason why is because I would basically consider that to be even though the termination initially was unlawful, the offer to be reinstated was declined. So, you could think of that as basically quitting, which is, it's not any knock on necessarily the employee's choice, but they are choosing to give up on the vesting schedule itself too. So I guess the answer that I have is I don't know how the vesting schedule will continue unless part of the settlement to require reinstatement also said, we're going to vest some of those shares. So and maybe as I'm thinking about that, if it was considered improper and their ability to be reinstated kind of crossed over that 1 year cliff date. In other words, they're fired 2 weeks before the cliff date, reinstated 2 weeks after, but declined to continue. That's kind of gray. That's I would probably say they might be, I shouldn't have been fired, so I should have been able to vest. It's a claim, right? It's not really specific. I don't think there's any statutory requirement one way or the other, but if I were the employee, I would say, you've already lost. So why are you going to keep this from me? Because this is something I should have had in the first place. So, good luck arguing against that in front of a jury. So.
And I think, and I'll just tag a little bit onto that, and it's 4:30. I'll let everyone go out and enjoy the sunshine instead of hearing us talk about equity. But I think, contractually, usually the language in the contract is you have to provide continuous service, right? So in that incident, the continuous services cease. So contractually, maybe not, but practically, there probably would be some sort of settlement agreement, some sort of separation agreement, and part of that consideration for that will likely to be some of the equity.
Thanks, Doug. Thanks, Brandon. Yeah, Maya, you want to take us out with any admin comments?
Yeah, just a reminder that I'll be emailing out the paperwork in just a bit. If you called in, please email me. I already have one person who checked in, but if you called in, please email me if you don't get that email by like 5:30 today. And yeah, we will be providing a copy of the slides as the presentation materials along with the MCLE paperwork.
All right. Thanks, everybody.